I'm Kathleen and I'm a director in the UK inbound team based in Sheffield, and I've been working in immigration for 24 years now. I could always worry when I say that. It's been lovely to be a patron of Sheffield Chamber and a member now for the last 7 years. And we really find you such a brilliant organisation involved in so many great initiatives across the region. We love attending your networking events and reading all about the other member news. And we hope to be able to help members with ways in which immigration can support your business, either by hiring all the brilliant graduates, for example, from the universities across the region, any overseas talent already living here, or people that you want to hire from outside the UK. We also support businesses in getting the right visa to work overseas. And so we're really looking forward to attending the upcoming International Trade Conference, and hopefully you'll find out some good, useful information today. Thank you, and hand it over to my lovely colleague, Yini. Thank you, Yini.
Hi, everyone. My name's Yini. I'm a qualified solicitor based in our Sheffield office. My journey with Fragomen started since 2019, back in our Malaysia office, and I relocated to the UK in 2020. So I currently work in the UK inbound team and assist clients on a broad spectrum of UK immigration matters, including work authorizations, business visitors, etc. So that's me. Thank you.
Morning, everyone. Just by way of quick introduction, my name's Sian Thornby and I'm a manager of our dedicated compliance and audit practice within the UK. So primarily assisting with right to work and illegal working matters, manage the operations of our identity service provider solution, and also work on sponsor licensing compliance matters.
Thank you, Sian. So I'm having a look at the agenda. You can see here the areas we're going to cover. So what were the big changes in immigration law that might now affect you? What's the new immigration salary list? And what happened to the old shortage occupation list? We'll give specific examples of potential impact on the northern region and include a few case studies to bring it to life. We'll look at what other immigration options do you have if someone doesn't qualify for a visa under the new rules. We'll look at what's on the horizon for the rest of 2024. And then we'll look at the right to work check process, and we'll leave time for some questions at the end. So moving on to slide 4, what has actually changed? So Rishi Sunak gave his reasoning for the change last December, saying we'll stop immigration undercutting the salaries of British workers, will increase the skilled worker earnings threshold by a third to 38,700 from next spring, in line with the median full-time wage for those types of job. So the key changes that might affect you are the standard occupational stock code system has been overhauled, and what does this mean for you? So to sponsor individuals under the skilled worker, global mobility route and scale-up visa, employers must ensure the role they're offering meets the visa conditions. For example, what role that is a required skill level and pays the relevant minimum salary. To help the Home Office consider if a role meets the visa requirements, jobs that are eligible under these sponsored routes are listed by occupation code, and the occupation codes are used to identify the relevant going rates and salary threshold for each job, both at new entrant and experience rates, and provide details such as example job titles associated with that specific occupation code. Once the employer has selected the relevant SOC code, they can then assign a certificate of sponsorship to the applicant. And the big change that's affected employers the most is that salary thresholds for new applicants since April the 4th have been increased. So to hire someone under skilled worker route, so this is new hires to your business, either from overseas or already working here, the salary threshold is 38,700. So that's gone up from 26,200, a 40%, 8% increase. And you must pay someone the higher of the 38,700 or the medium going rate for the job. And that's gone up from the 25th percentile. So that means that all going rates are now higher as well. So to hire someone under the Global Business Mobility Senior and Specialist Worker route, the GBM route. This visa allows you to do an eligible job at your employer's UK branch. The salary is now 48,500, so that's up from 45,800. And the 25th percentile going rate must be paid, so lower than the medium needed for skilled workers. Salary thresholds for extensions and switches from within skilled worker have also increased, so that affects people who may already be working for you or another employer in the UK. Finally, the shortage occupation list, SOL, has been replaced with a new immigration salary list, and this affects the northern region even more so, as there used to be a 20% discount for the shortage occupation roles, which has been removed, and a large number of these were actually roles that were quite common in the region, like electrical engineers, for example, which no longer appear on the new immigration salary list. So moving on to slide 5, what does this all mean for employers? So you can see in this table the impact of the changes on what people need to be paid. And to pick out 2 examples, number 1, let's look at the new entrant category, as this is really helping some employers. A new entrant is usually in the early stages of their career, and if they can meet defined criteria, can be paid a reduced salary for a maximum of 4 years. You can see that for a new entrant applying from 4th of April this year, they need to be paid the higher of 30,960 or 70% of the going rate, the medium. And this is, again, still meaning that it's always 30,960 must be paid at least in this category. So it's definitely worth considering because it's less than a lot of the going rates. Number 2, similarly, if you hire someone whose role is on the immigration salary list, they need to be paid, again, 30,960 or the going rate, the medium going rate, whichever is higher. So you can see the various costs, but also how you can benefit from the new entrant and immigration salary list rates. So moving on to slide 6, how does all of this actually impact your business? So I've picked out here some of the most common SOC codes from the northern-based clients that our team helps. So you can see the actual amount that needs to be paid. If we look at programmers and software development professionals as an example, we support many gaming and digital clients in our team, and this is one of the most common roles that they're finding it really hard to recruit for. So before the 4th of April this year, programmers and software developers needed to be paid 34,000, but now the going rate for them is 49,400. However, our clients are happy that you can see graphic and multimedia designers appearing on the immigration salary list. But even though they appear on there, the going rate for them has still gone up from 23,000 to 30,960. So you can see this is having a really big effect on our clients' hiring. And again, just to reiterate, if you're a new entrant, so the early stages of your career, the standard rate of 30,960 applies for all of the roles, or 70% of the new going rate. So whichever of those is higher. And to just look at finally some employment trends in the north of England more generally, so you can see how it affects it. The top 6 jobs this year in the north of England are education. So there are different salary rules if you work in some education jobs, and the going rates for these jobs are based on the national pay scale set by the relevant independent body. Number 2, top job healthcare. So there are different salary rules again if you work in some healthcare jobs. The going rates for these jobs are based on the national pay scales, again set by the relevant bodies, in this case the NHS. 3rd is engineering and manufacturing, really big in the region. IT, programming and data, then construction, and finally retail, and that includes jobs in hospitality and tourism. So I'm going to hand over to Yini to have a look at some case studies to sort of help you bring it to life. Thank you, Yini.
Thank you, Kathleen. So these case studies that I will go through, it's for better understanding and visualizing how the changes impact businesses. For ABC pipelines, for example, hold a sponsor license and they wish to employ an Indian national to fill an electrical engineer role in the Sheffield office. So assuming that this is an indefinite permanent role, skilled worker visa route would be the preferred one. And the proposed salary here was 40,000 based on a 37.5-hour week. Last year, they moved a US employee into a similar role and have benchmarked the salary in accordance with other workforce with similar qualifications and experience. If you remember from the previous slide, an electrical engineer will now fall under the SOC code 2123. So before the change of rules, the minimum salary is 39,300. However, after 4th of April, the business will find it hard to learn that for them to sponsor the Indian national, they'll now need to pay a salary for at least 53,500, which is a massive leap of over 10,000. So the challenge here is that they won't be able to increase salary bands for the entire workforce at this level. So what are the options that we can explore? Kathleen has mentioned the new entrants or roles on the immigration salary list. So they will continue to benefit from a reduced salary discount. And given the significant increases to the general salary threshold and the going rates, it's only natural that businesses will now be more keen to explore the new entrant provisions. So some corporate sponsors usually rely on the new entrant rules when hiring graduates to meet the salary threshold, and may sometimes find that annual salary increments may result in their sponsored employees reaching the higher salary amount after 4 years through natural salary progression. So for a new entrant applicant is usually in the early stages of their career, and if they meet certain criteria, they can be paid a reduced salary for a maximum of 4 years. I won't go into too much details here regarding the defined criteria. I just want to highlight the criteria that are more commonly relied on by businesses, by our clients that we assist. So one of the most straightforward options is that the applicant is under the age of 26 on the date of application. So here, ABC Pipeline can look at what age is the Indian national that they plan to hire and whether they can benefit from the new entrant rate. So would the advice change if they find a candidate who is already in the UK on a student visa or graduate visa? So this will bring us to the next slide with another case study to better visualize this. Here, the business need to fill a security consultant role. Salary on offer is 35,000. So for a cyber security professional, this role will fall under 2135, and the new salary threshold would be 45,300. In this case study, a postgrad applicant on a graduate visa from Manchester University applies. They fulfill all criteria, have the necessary experience, and they tell the business that they might be able to benefit from a new entrant rate. So what would this mean? As mentioned earlier in the previous case study, a skilled worker applicant can be a new entrant if they meet one of the 7 options. Another 2 are more commonly relied on. Applicant's most recent permission was under Tier 4 or student route and meets conditions for switching to skilled worker. And applicant's most recent permission was under the graduate route. You can see the pattern here. It's more focus on graduates that are already in the UK. So although those on the graduate visa benefit from this discounted salary threshold, time spent on the graduate visa may limit the length of time they can be sponsored. If you remember, it was maximum of 4 years on the new entrant provision. So an applicant relying on the new entrant can only be sponsored 4 years, and this 4-year period includes time spent on graduate visa or skilled worker visa. So in practice, this effectively means that when switching from a graduate visa to the skilled worker, if the applicant switches at the end of their 2-year graduate visa, they can only be sponsored for another 2 years, relying on the new entrant provision. So in this instance, they can, of course, look to extend, but at the point of extension of the skilled worker, they will no longer be able to utilize new entrant discounted rates. So I hope the 2 case studies helped you understand better the impact of changes of salary threshold on 4th of April. So now you might wonder, what if we can't use new entrant rates for whatever reason and we can't sponsor the employee on skilled worker route? So there are other unsponsored routes that the business can also look at to explore in this instance. For example, spouse or partner of a British citizen or settled person in the UK, EU national with USS status, dependent visa holders, etc. And the key features for unsponsored routes are that first, they are more cost effective compared to sponsored route because they don't trigger immigration skills charge, which is a cost associated with sponsorship. And they are also of interest to those who need and want that flexibility to be able to work on different contracts, different employers throughout their duration of visa, depending on the availability of work, because they don't need to stick with just one employer throughout their visa. And some of the unsponsored routes have less strict English language requirements, which we commonly see this sometimes can be a challenge for skilled worker applicants to meet. And some categories also lead to permanent residence, for example, spouse or partner of a British citizen or settled person. So there are also other considerations to take into account when exploring the unsponsored routes. So it's not all good. Some of them, for example, high potential individual and youth mobility routes have maximum durations of visas which are shorter and don't allow extensions once they hit the maximum duration. And also policy changes could also impact certain categories. And with the recent announcement of the general election on 4th of July, immigration policies will definitely be one of the key battlegrounds between parties, and we shall wait and see if the UK's approach to business immigration need to change to reduce the economic disparity between the North and the South. Thank you. Yeah. I'll pass back to Kathleen for the next slide.
Thank you, Uni. So Fragomen can help in many ways. We're helping all our clients in the minute, mostly with reporting. So the screen we showed you on roles and salaries, we're helping a lot of clients with that. So which roles are affected. We're looking at other visa options, all of the ones that Uni just went through, and we can always help with looking at alternatives. A lot of clients using new entrant, for example. Helping with draft communication. So because your employees need to know this information, how can we communicate that in the best way? And also people who are currently in your business and might be coming up for extension, how will it impact them? Also people in your workforce already may have heard the news and want to know if they work with a sponsored worker, is that person maybe going to be paid more than me, for example? And a big way we can help is liaising with the Migration Advisory Committee, who is going to do a consultation very soon, hopefully, on what roles should be on the immigration salary list. And that's your chance as a business to feedback and say, for example, I'm in engineering, I'm finding it really hard to recruit these roles. And if enough engineering businesses do that, then the Home Office will sit up and listen and should take account of that. So we'll help when that comes out, we'll publicise it and we'll help businesses to complete in the best way for them. So that's a really key way we're helping as well. Moving on to the next slide, please, Shan, just to have a look at what are the other hot topics in UK immigration at the minute. So the transition to e-visas from the biometric residence permit cards that people currently have is a real hot topic for employers at the minute. So if any of you already sponsor overseas workers, you may already have had queries about this. The current BRP cards are due to expire in December 2024, and they'll be replaced by e-visas. And those without an online account with the UK Visas and Immigration Department, so the UKVI at the Home Office, need to register and set up online accounts so that they can share their immigration status going forward, whether that's with employers or landlords, for example. And access to online UKVI accounts will be open during the summer. I know we're here supposedly already, so we'll let everyone know once that's open. Everyone who needs one will then be able to get one of these accounts. And how will this then affect right to work checks? So if an employer conducted a manual check before 6th of April 2022, the check will only cover the validity period of the physical document, for example, a passport. So if the immigration permission is valid for longer than the physical document expiry date, then a further right to work check will need to be completed before the expiry of the BRP. Now we're just waiting for Home Office guidance on this, and again, we'll issue an alert as soon as we know more. And this check would then need to be completed using the online right to work service. However, if the physical document showed permanent status like settlement in the UK, then no further right to work check is needed as long as the initial check was done correctly. Finally, if an employer carried out a right to work check correctly on or after 6th of April 2022, then they don't need to carry out a further check. So we're helping our clients with communications again to their employees on how to, what they need to do, audits of employers by the Home Office we're helping with, getting people ready, what right to work checks are needed and when, and analysing the workforce for you to see who that would be. And Shan, who leads our compliance team, is kindly going to give you some really good practical advice on how this whole process can be streamlined in the next slides. So moving on to slide 12, Shan. Another hot topic applies to Europeans that you may employ. So 5 years since the UK EU settlement scheme, EUSS for short, was launched, the UK has introduced some really good changes to how it will all work. So Europeans living in the UK on or before the 31st of December 2020 had to apply to the EUSS for confirmation of their right to work status, to show that to apply to the EUS for confirmation of the right to reside in the UK. Their non-European family members could also qualify. Individuals who were granted pre-settle status for 5 years or settled status if they could evidence that they'd lived in the UK for a 5-year period. So the expectation was that individuals would apply for settled status, which allows them to live and work here permanently once they're eligible to continue to benefit under the scheme. So the changes that are really good are that those with EUSS will now be granted a 5-year extension before their leave expires, and the Home Office has automatically started switching as many eligible people as possible to settled status without needing to apply themselves. And this change also affects your right to work check process again, as for anyone employed on or before the 30th of June 21, employers don't need to carry out a further right to work check, but you might like to remind these individuals to apply for settled status. Whereas for those employed from July 2021, employers will need to carry out a new right to work check before the expiry of their pre-settled status. So in this area, we're also helping our clients with communications to their employees, what they need to do, advising on whether the employer needs to carry out another right to work check. And again, it's a great time to look at whether right to work check processes are all compliant, because the penalties have been increased significantly if they aren't. And so on that note, I'm going to hand over to the guru of this, Shan, to talk about right to work checks and our tool WorkRight, which makes the whole process a lot easier, more streamlined. Thank you, Shan.
Thank you so much, Kathleen. And just before I move on to the next slide, I just wanted to add in relation to right to work checks for those with pre-settled status. From the 21st of May 2024, so this year, just a couple of weeks ago, UKVI announced that with the auto extension of the pre-settled status and converting that into settled status, employers who have carried out a right to work check on an individual with pre-settled status will no longer be required to carry out a further right to work check in order to maintain their statutory defence. So if you do have documentation on file which proves someone's right to work and it's time limited, but time limited on the basis of settled status, you no longer have to carry out a further right to work check. However, many of our clients are considering this on a risk-based approach and are choosing to continue to undertake a right to work check to ensure that they've got evidence that there is no expiry linked to that person's visa anymore. Okay, so right to work checks. I'm sure you are all familiar with or aware of the methods of conducting right to work checks in the UK. So there are currently three. The first is a manual right to work check. So down the middle of the screen, you will see manual right to work check. You should all be familiar with this as employers. It's the traditional in-person right to work check where somebody brings their documents into you for you to carry out that right to work check. Now, this is only applicable at the moment to individuals who are UK citizens, Irish citizens with a passport, either valid or expired, or somebody with a vignette in their passport or hard copy right to work documentation, such as a birth certificate and national insurance number, for example. So if you are carrying out a manual right to work check, we recommend that you look at list A and B of the Home Office guidance in order to determine whether the documents that the individual have presented to you are sufficient to generate statutory defence. The other option is online right to work check. Sorry, I just moved the slide there. So online right to work check is using the Home Office's online right to work checking service. So from the 6th of April 2022, so we're just over 2-year mark now of using this. The Home Office mandated that this is used for everybody who has an e-visa, a BRP, a biometric residence card, or a frontier worker permit. And what that means is you can verify that person's status online. Now, this is part of the government's digital by default agenda. So they're moving to a more digitalized status for visa holders, but also was driven by COVID. So during COVID, it was increasingly difficult for employers to be able to obtain original documents from individuals when starting work. So being able to verify someone's right to work online was a huge benefit, especially for visa holders. So what you need to do in this scenario is ask your employee or prospective employee to generate what's known as a share code. So a share code is a 9-digit code, which is unique to an individual, and it's valid for 90 days. And during that 90 days, you have to go to the employer part of the online service, input the share code and view the person's right to work profile. And when you view that profile, you'll be able to see the person's permission status, any expiry linked to that status, and also their image and their picture. You will need, as an employer, to check that the person on the image is the person who is presenting for work in order to generate statutory defence. Now, the Home Office, interestingly, don't mandate how you do that likeness check. So unlike with manual right to work checks, you have to be in the presence of the person holding the original document. With online right to work checks, you can verify the person's likeness via Zoom or Teams, however that works for your business, but you don't need to be in person with the individual. And then finally, and because the focus of the session today is how can you digitalise your right to work check programme or your processes, the Home Office introduced the ability to verify someone's right to work through the services of an identity service provider. or an IDSP, as you may hear it referred to commonly. So this is the Home Office's answer to digital checks for UK and Irish nationals. It's in a beta testing phase at the moment, so it's only applicable to British and Irish nationals with a valid passport or valid passport card. Anyone with expired passports or differing documentation would have to go down the manual right to work check process. Although from research, we believe that probably around 85% of most workforces would have a valid passport in order to utilise the identity service provider route. So the real benefit of using an identity service provider is that it's technology driven. So AI does the verifications for you. The person has to upload a copy of their passport and take a selfie, and then the technology carries out the facial recognition and confirms whether a person has a right to work or not. So as Kathleen mentioned earlier, we do have an identity service provider solution, and we are certified to a medium level of confidence as required by the Home Office. Now, our platform is called WorkRight, and the real aim of WorkRight is to remove the work out of the right to work checks and ensure that the system is carrying out the compliant right to work checks for you without your teams having to have real hosts and reams of information and knowledge on right to work. So the process will differ per every IDSP. It shouldn't differ too much, but you will see if you engage with different providers, there might be slightly different processes. But for WorkRight, you are given access to a platform. You can initiate right to work checks using that platform or via your HR systems through an API. Once you initiate a right to work check for an individual, it works very similarly to a background check. The person will receive an email. They'll click on a secure link in the email. They will, as I mentioned earlier, be required to take a selfie, take a picture of their passport, and then the system determines what route the individual needs to go down, whether they can benefit from the identity service provider route, whether they're a BRP holder and they need to provide their share code, or whether they come for an in-person check. And then there's a report that's produced, which confirms what you need to do next as an employer to prove a person's right to work in the UK. And once that's been done, you're provided with a report, an output. So the report looks similar to this, as you can see here, and it's almost akin to what you would see on the online right to work portal for visa holders. So the first page captures the candidate's images, confirms that the document is genuine and the facial recognition is complete. We also run an identity check to ensure that the person who's claiming that identity, the identity does belong to them. And that includes running mortality and synthetic identity checks as well. And then we also run PEPs and sanctions checks, which are detailed on the report. And most importantly, there's the right to work check decision. So it's either confirmed or not confirmed, which allows you at a glance to be able to see whether you can proceed with that hire or not. If the right to work decision is not confirmed, there is additional verbiage on the report to confirm why the right to work is not confirmed and what you need to do next as an employer in order to successfully onboard and generate a statutory defence that's needed for right to work purposes. So that's really WorkRight in a nutshell, how it works and how you're able to digitalise your processes. The WorkRight platform is supplemented by dashboard reporting and also managed services available. So if you do require any further information into WorkRight or want to know more, please do reach out to me or my team at the emails that you'll receive after this webinar, and I will be more than happy to support. And I think, Kathleen, I'm handing back over to you now to run through what I need to do next.
That will be me, Sian.
Oh,
Thank you.
sorry, Yumi.
No problem. Yeah, so very quickly, this is just about how businesses can prepare for the change or any upcoming changes. So we should reassure any impacted employees that everything's going to be all right. We got everything in control. And of course, we need to assess who is or will be impacted, including where those may no longer be able to switch route, and ensure different business units such as talent acquisition, recruitment team, HR, hiring managers are aware of the changes and that workforce planning is action where required. And like Kathleen mentioned earlier, Fragomen has bespoke report or analysis showing the overview of changes, examples of impacted salaries tailored to different industries. We also often have complementary fact sheets or FAQs to help businesses navigating those changes or any necessary communications. We also monitor closely and engage with MAC's recommendation, a review of any policy changes. For example, the most recent one would be the graduate route, which has recently been recommended to remain in place in its current form. So if any support is needed at all with any of the changes, or just simply to discuss what these changes mean for your business or population, please don't hesitate to contact us, and Fragomen will be more than happy to help in any way. Thank you.
I can see a question in the chat from John regarding right to work checks, so I'm happy to take that one. So John's asked, if the person moves into a new position, will the new employer have to do this process again, or will the original right to work check suffice? So John, I don't know if you're able to unmute yourself, but I'd have a couple of clarification questions there before being able to respond. Do you mean a new position with the same employer, or do you mean a completely new employer?
Sorry, yeah, a completely, well, a new employer, yeah.
Yep. So if it's a new employer, the right to work checks aren't transferable between businesses unless a TUPE transfer has applied. So if it's a brand new contract of employment where no TUPE is applicable, the new receiving employer would have to carry out a right to work check on or before day one of employment in order to be compliant.
Right, okay, thank you.
No problem. And I think we can now open the floor up to any other questions or comments that anyone has before we close.
I have a couple on, oh, yep, Sam's put one through. Do that one first on the chat, Sean.
Oh, perfect. Question regarding new entrant salary. If an employer can rely upon this for 4 years, do they then have to bump up the employee to the lowest minimum salary after the 4 years? And presumably the time period doesn't start again.
I'll take this question, Sean. So regarding the new entrant salary, once they do hit the 4-year maximum, they will then need to meet the new salary threshold. So naturally, we will think employers will need to bump the salary up to meet the new salary threshold after 4 years. But consideration needs to be taken regarding genuine vacancy. So a really huge bump on salary might might raise some red flags for UKVA to question whether this is a genuine vacancy. And as I mentioned earlier, when I go through the new entrant, so for new entrant applicants, most of the clients find that as they progress naturally for the 4 years, they normally will eventually hit the higher salary threshold at the end of the 4 years. So we will caveat it when employers would like to bump the salary up to the new minimum salary threshold. Does it make sense, Sam? Thank you.
I think just to add there, Yini, as well,
Yes.
one thing that I would recommend for employers specifically with that, and coming at this with a compliance head on from the compliance practice, I think early communication and early conversations with the employee is key. So if you do not believe at the end of the 4 years that the person will be able to hit that salary threshold and the business would not be able to support that because either it's just too high or other people in a similar position aren't going to be on that salary and you don't want to face a discriminatory claim, you really need to consider having those conversations early about what would happen at the 4 years. And then just touching on the genuineness of inflation of salary, the Home Office are really investigating this at audits at the moment. And if salaries are artificially inflated or are more than other people in a similar role, it could result in the loss of the sponsor license or a downgrade of any sponsor license. So it's really important to consider all of those aspects when you're looking to hire someone in the new entrant salary banding.
And just to answer Anne's question and on the chat, presumably the time period doesn't start again. So once an applicant hit 4 years, they cannot apply as a new entrant applicant anymore. So they won't give you another 4-year period. So they will need to meet the standard minimum salary threshold after the 4 years.
I have a couple of questions, if that's all right. If an organisation cannot sponsor an employee to work in the UK for various reasons, can't meet certain requirements and stuff like that, but they're needed in the UK for meetings or training, how can the organisation determine someone can travel to the UK without a work visa for business purposes?
I'll take that one. Thank you. So this is also one of the areas that Fragomen can help businesses to assess. Assess whether a business traveler can indeed travel as a visitor. And those entering the UK as a visitor can work, but only as expressly allowed under the permitted activities set out in the rule. It will ultimately depend on the nature of the activity to be undertaken, such as delivering workshop or attending meetings. So that will be something that we need to assess with further details. So yeah, hope that answered the questions.
Thank you. Just another one, just regarding e-visas. Once a visa holder created their UK VI account and managed to view their e-visa, will they still be required to return to the BRP expiring on the December 24, or to the Home Office, or if they still need it for travelling despite having the e-visa?
So it's expressly stated on the fact sheets from UKVI that BRP holders should continue to carry both the BRP, the in-date BRP, and their passport when travel internationally. Although the Home Office is currently taking steps to allow carriers to securely access the immigration status for passengers, but during this transition period, I believe this continue to carry the BRP will provide an extra layer of assurance for the travelers in the event if there's any technical issues of viewing their digital immigration status. So yeah.
Thank you. That's it from me. Any more questions from guests at all? I think that might be. So anything else you'd like to add, Kathleen, Yini, Sean?
Not from me, other than just a thank you. Thanks very much, everyone, for attending and for hosting us, the EJ. It's lovely to have an opportunity to speak to people, and we'll send out all our contact details afterwards, and please do get in touch. It's nice for us to speak to people individually as well and see what's going on. Good for us to get insights into businesses in the region. So really appreciate having the opportunity today. Thank you.
That's brilliant. Just to echo that, Kathleen, thank you for delivering the session. And yes, I will follow up with contact details for you to get in touch with Kathleen, Yini, and Sean directly if you have any questions. But I think we'll bring it to a close. So thank you. Have a lovely day, everyone.
Thank you.
Thanks, everyone.
Bye.